Hi, my name is Olivia Mitten. I'm a special education teacher at Waterford Mott High School, and today we're going to talk about 4 myths regarding discipline for students with disabilities. To give you a little background, ADA, or the Americans with Disabilities Act, and IDEA, the Individuals with Disabilities Act, were all enacted to provide rights and procedures for students with disabilities and to provide public service access to students with disabilities. And prior to these laws, students with disabilities were excluded from public education. Despite ADA and IDEA, though, students with disabilities are still punished at a disproportionate rate and are far more likely to be disciplined, removed, suspended, and expelled. A report from the U.S. Commission on Civil Rights shows that special education students with a range of disabilities are suspended at twice the rate of non-disabled students, and that zero-tolerance policies contribute to a high rate of suspension, especially for minority students. The restorative justice principles that are commonplace in schools today focus on restoring relationships, preventing behavior, and impacts on the community when a student is suspended, expelled, or within a violation of the school code of conduct. And they can boost students' success by keeping them in school and engaged in the community of learning. My framework for this presentation today is the Supreme Court case Honing v. Doe, and the court's decision on this case really sets the framework for a lot of our principles of disciplining students with disabilities today. So in this case, John Doe was a 17-year-old student with emotional impairments. In 8th grade in 1980, while at school, it was noted that he had impulse control and anger issues. And when a student taunted him in the hallway, he reacted violently by choking another student. And on the way to the principal's office, he kicked in a window and broke it. He was therefore suspended for 5 days and the placement committee then notified his mother later on that he had been recommended for expulsion and that the suspension would be extended until the expulsion hearing was complete. Doe's mother argued that the suspension violated the stay put provision of EHA and ultimately filed a lawsuit. Jack Smith, another student with emotional impairment, had a history of verbal hostility toward other students, and in middle school he often would steal, cheat, and harass other classmates, and he was suspended for 5 days following an inappropriate comment made to a female student. As a result, the district suspended him for 5 days and recommended him for expulsion, and ultimately Smith withdrew and joined Doe's case for that indefinite suspension model. The court's decisions around this case really set the groundwork for what we use today in disciplining students with disabilities. So the court decided that they changed the rule from 5 days to 10 days before an MDR must occur, and they reacted to the school district's kind of alleged dangerous exception rule by saying that dangerous students should be dealt with within the school using study carrels, timeouts, and detention or other behavior intervention plans. They also reacted to kind of the exception that drugs and weapons can earn students suspension of 45 days without parental consent, and that students with disabilities cannot be expelled pending the outcome of administrative review, and that IEP teams must meet with MDR and conduct observations before making a decision, and that states have to offer services to students when schools cannot provide them. And the intention behind these was both to protect the students' right to free access to public education or FAPE, and also to protect them from being excluded through expulsion from schools altogether. So this brings us to myth number 1, that IEPs for students with disabilities hinder effective behavior management of that student. Oftentimes you'll hear teachers say that student has an IEP, therefore we can't punish them. But in reality, IEPs are intended to address behaviors directly. So IEPs are a vehicle for effective behavior management, and they're designed to address or note traditional and behavioral needs of the student as a result of the disability. The law also states that schools shall consider strategies including positive behavior interventions to support or address behavior impeding learning. Without effective behavior plans, a disciplinary action resulting in suspension, expulsion, or change in placement may inhibit a child from receiving FAPE and therefore violate their civil rights. And this brings us to myth number 2. Students with disabilities cannot be expelled from school for serious code of conduct violations like weapons or drugs. In reality, violations, especially those of safety, require quick and deliberate administrative action. When a student violates a rule involving weapons or drugs, safety of all students and staff should be priority number 1 for both administrators and staff. IDEA also requires initiating an IEP meeting within 10 days of removal, and removal from special education for more than 10 days violates their right to FAPE unless the 45-day rule applies. And a change in placement can occur with a review of the IEP and a functional assessment. It should be noted that students with disabilities have a higher propensity for addiction and drug use, and therefore restorative practices can be really useful in addressing issues such as vaping for students with disabilities, where we consider the health risks as well as the disciplinary actions of the student, and try to really get them to think about what harm did they cause to other students and themselves, and what was the decision-making process that went into that, and what other factors could be affecting their prevention in the future. So in Michigan, the MARS application here is that a child with a disability who is removed from the current placement must continue to receive educational services to participate in the general education curriculum, although they're in another setting, and progress toward their IEP goals. And they also need to receive a functional behavioral assessment and a behavioral intervention service modifications designed to address the behavior violation so that it doesn't reoccur. And this is where restorative practices can really facilitate that conversation within the team and with the student and the parent in addressing not just the punishment aspect, but also the relational aspect and the social aspect. And this brings us to myth number 3. MDRs are held and students with disabilities will get punished less because of this meeting or because of their disability. In reality, MDRs are just to determine if the violation was a result of the disability. If the violation is determined to be not a result of the disability, they are still punished equally to their non-disabled peers, barring the 10-day and 45-day rules. So when the IEP has addressed a problem behavior, the team has information between the student's disability and the behavioral concerns. In the case of John Doe and Jack Smith, the IEP had already noted those problem behaviors and were working to address them. When a suspension or a 45-day alternate placement is recommended, the team should determine if the misconduct is related to the disability. And if it is determined that the misconduct is related to the disability, the team discusses if the current placement is appropriate, evaluates the factors related to the behavior in the IEP, reviews the interventions, and provide strategies to resolve the problem and prevent future occurrences. And again, restorative justice practices can help facilitate that window or that opportunity for conversation. And in the case of John Doe, maybe it resulted in him repairing the window or hearing what harm he had caused the victim and talking through strategies to prevent that in the future. So the manifestation determination in Michigan needs to occur within 10 days of a change of placement, and the IEP team and all relevant members and information must be considered, and you have to decide if it was caused by or had relationship to the disability, if it was a result of a failure to implement an IEP or a behavior plan, and if the parent and relevant members need to determine what condition was met and then where to go from there or immediate steps. They also must determine either the conduct of a functional behavioral assessment and any intervention plan, and then if a behavioral intervention plan was already in place, they have to review it, modify it, and address the behavior. Special circumstances like weapons and drugs or serious bodily injury or harm can also be considered and added. So this brings us to myth number 4. Using alternatives to suspension like restorative justice or PBIS puts students' safety at risk. And in reality, zero tolerance, we know, has been really disproportionately affecting students with disabilities and minorities, and restorative justice offers a tool or a vehicle for these conversations and relationship with the school community among both those who are harmed and those causing the harm. And it really provides extra tools that we can use to engage students in the thinking process and the learning process in order to prevent behavior, restore relationships, and reconcile within the community. All tools that they will need to be successful as adults in the future as well. In different case, Davis versus Monroe, the court established basically that all students have a right to free education, and therefore school districts have a responsibility to respond to peer-to-peer conflicts regardless of a disability. Restorative justice can turn discipline process into a learning opportunity and help build strong and lasting relationships between students, schools, staff, families, and members of the community. And rather than suspension or expulsion, we are engaging the learner and the student in the school community and talking about them with how to engage in the community and also how to reintegrate once a suspension has occurred. So just to summarize, this court ruling in Honing v. Doe, ultimately it protects students from discrimination because historically they have previously been excluded. It offers there is also the MDR and the IEP, where schools must help students when behavior is caused by a disability, like a learning or a thinking difference, and consider how that resulted in the behavior and address it through the IEP and behavior modifications or intervention plans. And it establishes the parent's right to appeal those MDR decisions through due process or mediation. And it asks schools to consider what actions or alternatives to suspensions they can take in order to prevent discipline from reoccurring and address it when it does occur. Here are my sources. We're excited and consulted if you have any questions or want any more information. All of these are available to you as well. I just want to thank you for listening and taking this time to hear what I have to say, and I hope that this helps clarify some common myths or misunderstandings regarding discipline for students with disabilities and a better understanding of the intention behind the laws in protecting the rights of students with disabilities to receive a free and appropriate public education, and really emphasizes, the importance, which I identify with as keeping students in school and engaged in that school community whenever possible in order to provide the best possible education we can give them. And so restorative justice practices and other laws such as what we saw here today really, I think, help engage the learners in the school community, keep them in the community, and then ultimately repair any harm done through their actions as they learn to manage their behavior. Thank you again for watching, and I'll see you soon.